The Places of Worship Act 1991 is a legislative measure that plays a crucial role in safeguarding the religious character of places of worship in India. Enacted during the period marked by heightened tension related to Ram Janmabhoomi Babri Masjid dispute, the Act is designed to prevent the conversion of places of worship and to maintain the religious character of such sites as it existed on August 15, 1947. This essay explores the key provisions of the Places of Worship Act, its historical context, and the current challenges it faces. The primary objective of the Places of Worship Act 1991 is evident in its prohibition of the conversion of any place of worship. Section 3 of the Act explicitly states that no person shall convert any place of worship of any religious denomination or any section thereof into a place of worship of a different section of the same religious denomination or of a different religious denomination or any section thereof. This prohibition is essential for preserving the sanctity and religious identity of places of worship. This provision underscores the commitment to maintaining the status quo of religious sites as of the time of India's independence. However, the Act allows for the legal action if the change in the status occurred after the cut-off date. An illustrative example of the legal implications of the Places of Worship Act is the Gyanvapi Mosque suit filed in 1991. This lawsuit aimed to restore an ancient temple at the site where the Gyanvapi Mosque presently stands, highlighting the contentious nature of religious disputes and the importance of the legal framework in addressing them. Additionally, it exempts certain categories of places of worship, such as those considered ancient and historical monuments or archaeological sites, covered by the Ancient Monuments and Archaeological Sites and Remains Act 1958. The Act also excludes the suits that have been finally settled, disputes resolved by the parties, or conversions by the acquiescents before the Act's commencement. The enactment of the Places of Worship Special Provisions Act in 1991 occurred against the backdrop of Ram Janmabhoomi movement and the Babri Masjid controversy. The Congress government led by Prime Minister P.V. Narasimha Rao introduced the legislation to address the recurring controversies surrounding the conversion of places of worship. The then Home Minister S.B. Chavan emphasized the necessity of adopting these measures to prevent the communal tensions and controversies arising from such conversions. Two petitions challenging the validity of Places of Worship Act are currently pending before the Supreme Court. One petition filed by Vishwabhadra Pujari Purohit Mahasangh and followers of Sanatan Vedic religion questions the Act on the grounds that it bars the judicial review, imposes an arbitrary retrospective cut-off date, and abridges the right to religious for the Hindus, Jains, Buddhists, and Sikh. Another petition moved by Advocate Ashwini Upadhyay argues that the Act restricts the right to approach the court for reclaiming the religious places, particularly by Hindus, Jains, Buddhists, and Sikh. The Supreme Court, in its 2019 Ayodhya verdict, acknowledged the significance of the Places of Worship Act. The court highlighted that the Act manifests the secular values of the Constitution and strictly prohibits retrogression. In conclusion, the Places of Worship Act 1991 stands as a critical piece of legislation in India aimed at maintaining the religious character of places of worship and preventing their conversion. As the legal landscape evolves, the Places of Worship Act remains a pivotal element in the broader discourse surrounding the religious freedom, heritage, preservation, and delicate balance between various communities in Indian context. This is Meera Verma for Legally Speaking.